Okay, I believe ORS had stood up next, so we'll.
Commissioners, Eric Amstutz, representing the ORS in these proceedings. I'm with the Weich Law Firm. Ms. Lapson, I have just a few questions for you. I don't think I'll be holding you up from getting back to where you need to go. Are you familiar with S&P's most recent credit report that you attached of August 23rd, 2018, that you attached to your rebuttal testimony as an exhibit, EL1?
Yes, I am.
And that is...
Let me get to that.
Sure. And a copy of some of the pages are on the screen.
Yes.
Looking at... let's look at a few things that S&P in that report say about SCE&G. And to put it in context, this August 23, 2018 is after the experimental rate had been put in place.
Yes.
And the federal court had decided not to enjoin the experimental rate. You agree with that?
Yes.
Let's look at page 2 and the highlighted language there. It says liquidity, this is talking about SCE&G. Liquidity is adequate to meet projected needs, but also depends on a reasonable solution to nuclear cost recovery. Do you remember that statement?
I see it on the page, yes.
Looking further down the page, again, the highlighted language. We, meaning S&P, could lower ratings again if credit metrics weaken further beyond those in our base case scenario in which we assume the temporary rate cut is permanent. Do you see that language?
Yes.
And so their base rate scenario assumed permanency of the experimental rate. Is that correct?
Yes, I see that.
And then looking at the further down, it says, conversely, we could affirm ratings if the PSC does not require further rate credits or a rate reduction beyond the 15% reduction already assumed in our base case scenario. Do you remember that?
Yes, I see that.
Let's turn to page 4. There, the highlighted language says, we think that SCE&G has the ability to absorb high-impact, low-probability events without refinancing, and that it has well-established and solid relationships with banks, a generally high standing in credit markets, and prudent risk management. Do you recall that statement?
I see it on the page.
These statements by S&P are quite positive about SCE&G's financial conditions and prospects, even assuming that the permanent rates set by the Commission are no higher than the experimental rate. Is that correct?
Those are part of what they say. It's not the entirety of what they say in the course of the report. They have other statements in the report.
Thank you. Let's turn now to, you respond in your rebuttal to some of Mr. Richard Bodino's testimony. Do you recall that?
Yes, I do.
And have you read Mr. Richard Bodino's pre-file testimony in this proceeding?
Yes, I did.
And are you familiar with his recommendation that the return on equity for the allowed NND costs be based on the ROE appropriate for financially sound regulated utility companies and not on SCE&G's lower credit ratings?
Yes, I commented on that in my rebuttal testimony.
And I believe your response was that, to Mr. Bodino's recommendation, was that it was not a reasonable proposal. You say that the cost of equity must be determined by comparison with companies of comparable risk. And this was on page 8 of your rebuttal. Is that correct?
Yes, that is correct. I said that, however, that there might not be any companies, any utility companies currently of comparable weak financial condition. So the peer group that is used per force would be companies that are of higher financial quality, not of equal financial risk. And that in those circumstances, it is customary to make an adjustment to the ROE to, in some way, to reflect the higher financial risk of the company in question here.
Let's talk about that higher financial risk. Since early 2017, there have been reductions in SCE&G's credit ratings. Isn't that correct?
Yes.
And aren't all of those reductions in credit ratings traceable to, one, SCE&G's decision to abandon VC Summer 1 and 2, and two, to the claim that's being litigated in this proceeding that SCE&G mismanaged the project and engaged in misleading behavior?
Some of those, I think some of the credit rating changes are due to concerns about the political and legal environment, to the sustainability of the current cash flows, to the changes brought about by the imposition of the experimental rate, and certainly the controversies about the abandonment has been a major part of it.
And those controversies and that legislative and political environment, that's all traceable to the abandonment, ultimately to the abandonment of the VC Summer 1 and 2 plan. Isn't that correct?
That has certainly been a very important factor.
Did the ratepayers cause any of these consequences?
No, the ratepayers did not.
And in determining an appropriate return on equity, doesn't the Commission have to balance the interests of ratepayers and the interests of the shareholders?
I'd really like to share this question with my fellow panelist, Mr. Hevert, because he's not really been getting enough questions. And return on equity questions are really appropriate to Mr. Hevert more so than to me.
But you were responding to Mr. Bodino's return on equity recommendation.
That is a fair point. And I will say, since I did respond to it in my rebuttal, I would say that the return on equity is something that generates cash flow. And cash flow is the concern of fixed income investors who supply all of that capital in the form of bonds, and bankers who supply the credit facilities to the company. And so my concern about the adequacy of a return on equity has to do with the ability of the company to earn sufficient cash flows so that they can maintain investment-grade ratings and sustain enough margin of safety to make it possible to sustain a viable utility enterprise.
Is it your position that ratepayers should pay a higher return on equity because of the imprudence of SCE&G's management?
My statements about return on equity are all in the context of how to maintain a sufficiency of cash flow. And I am concerned about the cash flow of the company. And I think customers, even though customers don't feel that they are thinking about the bond market, credit ratings, and all of those things, customers don't have to think about that, but they think about having continual access to high reliability service. They want safe gas systems. They want reliable electric systems, and the company needs to maintain strong credit ratings, a strong reputation in the financial community, and good cash flow in order to make those things happen.
Isn't it the case that shareholders elect the board of SCANA?
In my knowledge, shareholders elect the board of directors of corporations.
And the board of directors here chose management.
I presume that to be the case. I haven't studied it.
So shouldn't the shareholders share some of their profit with the ratepayers through a more balanced return on equity?
I'm sorry, I'm not I really don't understand where you're going with this.
Thank you. I don't actually have any further questions for Ms. Lapson. Happy to, but I do have questions. I won't let Mr. Havert assume that I will have no questions for him. But if there are others who want to
Go ahead with Mr. Havert if you need to.
Okay. Mr. Havert, Eric Omstutz again. Approximately how many times have you testified before regulatory commissions about an appropriate return on equity?
Well, I've submitted testimony in about 250 proceedings. I would say the vast majority of those have been on cost of capital issues, and all of those have been on behalf of utilities.
And so you've never testified against the utility on return on equity issues?
I have not, but let me also say I've never been asked. I've not been asked by an attorney general, people's counsel. It's not to say I wouldn't, it's to say I've not been asked.
In your testimony, you provided a lot of information related to the return on equity that the commission should authorize here. Isn't that correct?
Let me break it into two parts. I've offered my sense of the return on equity, and I'm going to call it, and I don't mean to parse words, but the cost of equity. In this case, assuming the company maintains a strong financial profile, to the extent it does not, to the extent it falls below investment grade, to the extent its financial profile becomes severely compromised, then there would be an additional return required. So I've looked at it in those two pieces, if that answers your question.
Well, looking at your testimony, it appears that you've included information about the results of analyses you've done on various models of return on equity. You've also provided information about the returns on equity that regulatory commissions have authorized and on earned returns of equity and also pro forma rates of return. Is that correct?
You may be missing one piece, which is the expected earned return on common equity, the expected accounting return on common equity for companies. I've mentioned that in my testimony as well. But I think you've generally otherwise covered the bases.
And generally, a return on equity that is higher as compared to lower means that the ratepayers pay more. Isn't that correct?
So let's talk about that mathematically. Mathematically, to the extent the return on equity is a portion of the cost of equity, then yes, a higher number means a higher revenue requirement. That's a different question than what's the right cost of equity, what's the right return on equity. But if your question is, does a higher ROE number in the revenue requirement cause a higher revenue requirement than simply as a matter of math? Yes, it does.
Thank you. Looking at your rebuttal testimony, you included updated analyses of the models based on data through October 12 of 2018. Is that correct?
Yes, that is correct.
Do you recall that Richard Bodino, on behalf of ORS, filed surrebuttal testimony on October 29? Do you recall that?
I do indeed.
Did you read it?
Yes, sir.
And in that testimony, Mr. Bodino included a surrebuttal table 1, which he says, which is up on the screen, which he said summarized the mean and median results of your more recent analyses. Have you looked at that surrebuttal table 1?
I have, yes.
I can tell you that Mr. Bodino has reviewed recently this table and recognized that there were like you had acknowledged a few errors in your numbers, that there were a few errors of transmission in his numbers. And in particular, those first two lines, the 9.01 to 9.04 should be 9.01 to 9.15. The next number should be 8.89 to 9.06. These are all in the hundreds of percentages. And in the third line, that 9.08 ought to be 9.06 to 9.21. Otherwise, his numbers, he's confirmed his numbers. Now, we can use your numbers or we can use those numbers. I have put both up there. Happy to introduce into evidence the new numbers as summarizing your testimony more accurately, but I'd leave it up to you.
Oh, that's a call for you to make.
Well, I'm happy to introduce this into evidence.
That's fine, thank you.
Mr. Chairman, I do find it highly unusual for the lawyer to be correcting the testimony of the witness after the witness is already gone. So the record is clear. I don't think the lawyer can now try to correct the sworn testimony of a witness who's no longer here.
Sustained.
We're happy to work with surrebuttal table number 1.
I think all he's done is indicated that his witness has given sworn testimony that has errors in it and that he didn't catch until he left town.
Sustained.
That's a fair statement.
Yeah.
And they are insignificant, but we wanted the record to be correct.
Understand.
Looking at that surrebuttal table number 1, is it a fair summary of the mean and median results of your analyses included in your October 24 rebuttal testimony?
Well, I think with some of the discussion you just had, yes, it is.
Looking at that surrebuttal table number 1, it appears that you performed 9 return on equity analyses. Is this correct?
I'm sorry. So let's talk about it this way. So I performed the constant growth discounted cash flow model, the one method on which Mr. Baldino principally relies, the multi-stage discounted cash flow, the capital asset pricing model, and the empirical capital asset pricing model. And yes, within each of those, there were variants. So if that's your question, yes, I would agree.
Okay. And looking at those 9 analyses, 7 have ranges that are completely outside of what you say the range should be of 10.25% to 11%. Isn't that correct?
It's interesting. I looked at Mr. Baldino's Table 1 in his rebuttal and did some calculating of my own. When I look at the low end of my results, and this is based on his Table 1 as submitted, the 10.25% number, the low end of my range, falls in about the 64th percentile of all these numbers he has here in Table 1. It falls in about the 25th percentile of just the capital asset pricing model, empirical capital asset pricing model results. So it does fall toward the higher end of all results, but of course, I've got some concerns with some of those methods. It falls at the very low end, I think, of some of the risk premium based results. So I have looked at it, and even having reviewed these, I think my recommendations remain reasonable.
But of the 9, 7 of those have ranges outside of the range that you're recommending.
Right, which goes to the point I just made. Let's look at the 10.75 recommendation. That falls in about the 73rd percentile of these numbers in surrebuttal Table 1. It falls in about the 34th percentile of just the risk premium-based results. So this goes back to something I said earlier in my testimony. We have to think carefully about the models, how they conform, how they align with market conditions, and give them weight appropriately. So when I see that 10.75% falls in the bottom 34th percentile of risk premium-based results, it doesn't bother me.
Only one of those 9 at surrebuttal Table 1 supports your range. Is that correct?
I see lots of numbers that are higher than 10.25%.
Well, let's think of it. Your range is 10.25 to 11. So going down the table, I don't see any of those until the third to the last. And then the very last one is like 0.02% overlaps. Otherwise, it's totally outside of your range. Is that a
Right.
fair characterization?
It is, and again, I won't go through the percentiles again. I've gone through them twice, but that fits with what I said.
And aren't the ranges generated by two of your analyses lower than even Mr. Bodino's recommended 9.1%?
If you're talking about the constant growth discounted cash flow models, is that what you're?
Yes.
That's right, and of course, I discuss many of my concerns with that method in my testimony, and I'm happy to talk about them if you'd like.
It appears that out of these various analyses, 5 out of 9 support Mr. Bodino's 9.1%, and 1 of 9 supports your 10.75%. Is that correct?
So let's talk about that. And this goes back to, I think, part of my concern I had with Mr. Baldino's approach, which I mentioned in my summary, and that's his effectively sole reliance on one method. When you look at those numbers, 8.89%, there's not been a single vertically integrated electric utility that's been authorized to return that low as far as I know. The lowest I can think of is 9.1%. That's been observed only one time in New Mexico, which is one of the lowest rated jurisdictions by Regulatory Research Associates. So yes, that's what these numbers say. The question then becomes how much weight ought we give them? And in my view, I think we need to consider both the reasonableness of their results and why they're giving so low results.
You're criticizing Mr. Bodino's testimony as effectively relying on only one methodology. That's what I heard you just say.
That's what I said, and in my pre-filed rebuttal testimony as well.
But looking at this table, it appears that only one of those results effectively supports your recommendation.
No, and this is a point I also made in my rebuttal testimony. I said I believe in my direct testimony, made clear that I reviewed all the results. I consider all of them. And then I look to things that we just talked about. Where do they fall within the range of returns we see elsewhere? How do the model's underlying assumptions align with current and expected market conditions? What does it say about the effect of regulatory policy? Federal policy, federal monetary policy. How does that affect the models? This is an exercise that, in my view, is not given to looking at results, taking them as given, and taking an average. We have to understand the models themselves. So let me just go back and say, when I look at these model results and I see that 10.75% falls in about the 70th percentile of all the results, that includes all the results, the low ones as well. But to your point, as to it falls in the capital asset pricing model, the risk premium-based results, it falls at the 33rd percentile there. So I would not say I gave one method undue weight.
Now, you criticize Mr. Bodino for using just the discounted cash flow method, but didn't he also run analyses using the capital asset pricing model?
He did, and those numbers were about 8%, and I believe he discarded them as being too low.
Right, so they were actually lower than the model that he decided to use.
Right, and we can talk about why they produced such low models, and I have to say, I agree with Mr. Baldino that those numbers were too low to be reasonable. A return of 8% and lower is just too low to be reasonable.
But in deciding not to rely on those results, he was favoring the utility in that circumstance, wasn't he?
I wouldn't say that. I think Mr. Baldino honestly looked at his result. He thought it was unreasonable. I would say he thought it was not a reasonable estimate of the return equity investors require. That's what I do. I suspect that's what Mr. Baldino does as well. We obviously disagree as to how we get there and where we got, but I would say that's what he's trying to do.
Let's move to another area of disagreement between you and Mr. Baldino. On several of your analyses, the ones that generally generated the higher end results, you used projected as opposed to actual 30-year Treasury bond yields. Isn't that correct?
So let's break that down a little bit. Yes, I use projected Treasury yields, and yes, projected Treasury yields generally are higher simply because the capital markets are evolving and interest rates are increasing. But yes, that's correct.
Now, as I mentioned, this is an area in which you, Mr. Bodino, sharply disagree. He argues that actual yields in the marketplace already take into account projections since they're so public. And therefore, his position is that the Commission should not consider analyses that rely on projections of higher bond rates as opposed to actual bond rates. Is that correct?
It is, and I guess I've got a couple responses to that. One is that if it were the case that prices right now reflect all information regarding future interest rates, that they're all capitalized into the current price, then you would not see utility stock prices change concurrently with changes in interest rates, but they do. When interest rates move up and down, utility stock prices move up and down. So we know that utility stock prices and therefore valuations change with interest rates. Secondly, we can look at things like the slope of the yield curve and from that derive what the financial community thinks interest rates are going to be in the future. So we know that rates are expected to increase. We know that when they do, utility stock prices change. So I think it's entirely reasonable to use projected interest rates as part of the analyses.
Let's think about a bond investor. And as you just testified, the projections that seem to be in the marketplace are that yields on 30-year treasuries will increase.
Okay.
When yields in the marketplace on a 30-year treasury bond increase, what happens to the value of those bonds? It goes down, doesn't it?
Yes, bond prices move inversely to interest rates. It's an interesting point you bring up, but it suggests that bond investors are traders, that they don't buy treasury bonds as part of a buy and hold. And your question also suggests that there's no method for investors to hedge the effect of changes. And I don't think either of those two things are true.
If market participants knew that the yield on a bond was going to increase, they would know that it would lose value, correct?
They would, which is, again, why there are methods to hedge that risk. But probably the more important issue is that when investors buy bonds, especially long-term bonds, they'll enter into a series of trades for the purpose of duration matching, which is to say that they've got a liability, they know the term of that liability, and they buy treasury bonds to match that liability. It's not a trade strategy. It's typically a duration matching strategy. So there's no, it's not a market timing type of investment. It's more of a duration matching investment. But to your point, do bond prices go down as interest rates go up? Yes, they do. And that's part of the duration calculation.
Are you testifying that all bond trading is due to matching of maturities?
Of course not. But I'm saying that that's the case in a lot of circumstances, and certainly it's the case that a lot of bond trades are hedged as well. But I don't know that I would agree with your premise, which I think is that bond traders are principally market timers and take short-term trading positions.
But to the extent that bond traders are considering in buying a bond, whether or not that bond is going to go up or down in value, it would be irrational for somebody to buy a bond if they think and know that it's going to fall in value. So why should the Commission take into account irrational behavior as a methodology that makes sense?
I think I disagree with your premise. I don't think it is irrational. If a large institutional investor has a liability that they need to match, and they're going to buy a bond for the purpose of matching that liability, and they'll buy that bond for the purpose of holding it during the course of that liability. So I don't think in that sense it's irrational. But if your question assumes that all bondholders are simply traders, then perhaps you're right. I just don't agree with that premise.
Let's move on to the next area of your testimony, which was the returns on equity that have been authorized by regulatory commissions.
Okay.
And let's look at your rebuttal testimony of October 24, which included a chart number 1. Do you recall that?
All of my charts are special to me, so I've got to go. Can you tell me which page? Never mind, I found it. I found it. This one's particularly special, so I should know it.
And your chart 1 shows the ROEs that regulatory commissions around the country have actually authorized from 2014 to 2018. And looking at that chart, it appears to show that the most recent authorized ROEs by commissions are slightly above 9.50%. Is that correct?
Yeah, it's a good question. These are quarterly averages, but that's probably right. One thing we have to be a little bit careful about is from quarter to quarter, there can be different number of cases decided. There can be multiple cases decided within a given jurisdiction. But as to your question, yeah, I think that's right for that 1 quarter. I'd agree with that.
And isn't Mr. Baudino's recommended 9.10% much closer to 9.50 than is your 10.75%?
Well, it is, but I don't think. Let me back up. The purpose of this chart is to demonstrate that over time, regulatory commissions have recognized that the constant growth discounted cash flow model tends to produce results that are too low. That seems to have been happening for several years right now. And you're correct that the averages, the quarterly averages that I have here for the last quarter, it's a little bit over 9.5%, which, yes, I agree with you, that's closer to 9.1. But I've not been, I don't think it's appropriate to look at quarterly averages, annual averages, but I agree with your statement.
Have you read Mr. Baudino's surrebuttal testimony?
I have.
Let's look at pages 5 to 6 of that. And up on the screen, it shows that most of page 5 is made up of a surrebuttal table number 2, which took the information included in your rebuttal exhibit RBH-6 and lists the actual regulatory commission authorized ROEs for 2018. Isn't that correct?
Yes, that is correct.
And let's look at Mr. Baudino's summary at the bottom of page 5, running over to page 6. And it says, this table shows quite clearly how far out of the mainstream Mr. Hebert's 10.75% ROE recommendation is. According to the data presented by Mr. Hebert, the highest ROE award in 2018 was 10%, while the lowest was 8.80%. Although my 9.10% is near the low end of this range, it is within the range. Mr. Hebert's recommended 10.75% significantly exceeds the upper end of the range of 10% of allowed returns in 2018. Is Mr. Baudino's description of the facts here accurate?
His description is accurate, but he's using the data taken from my analyses for a different purpose than were intended in my analyses. And let me give you an example of why that's the case. If you look at his surrebuttal table 2, there are at least 8 cases that are for distribution-only companies, companies that do not own regulated generation. One of those cases, as I mentioned a bit ago, was in New Mexico, one of the lowest ranked jurisdictions. So when I included this data, it was for the purpose of my bond yield plus risk premium analysis. It was not for the purpose of comparing it to currently authorized returns. So My point simply is that I think he took my data, used it for a different purpose for which it was intended in my analyses, and if he's going to do that, then we need to look a little bit more closely at it. The only other thing I would add is we talked a little bit earlier today about Table 11 in my direct testimony, and I think there we see that the range for vertically integrated electric utilities that are in jurisdictions ranked somewhat higher, ranked where South Carolina had been, is in the 9.5 to 10.55% range.
But Mr. Bodino's surrebuttal table number 2 took data that were included in your exhibit.
Oh, I'm sorry, I didn't mean.
I'm sorry, was that data correct that you included in your exhibit?
It was, but as I said a minute ago, it was for a different purpose than for which Mr. Baldino has used it.
Thank you. Let's move now from authorized returns on equity to earned returns on equity in the proxy group. Can you explain what is meant by the company's earned return on equity?
Yeah, I'm glad you asked. It's a hairball, isn't it? There are a lot of these terms. The earned return on equity, in the way I look at it, is the accounting construct. It is the income available to shareholders divided by the average equity balance.
Okay, so let's look at page 62 of your August 2nd direct testimony. I'm
Okay.
sorry, let's go back to page 61. And there you note that since 2012, the annual median earned return on average common equity among the operating companies within the proxy group was in the range of 9.17% to 9.79%. And the median return over the entire period was 9.54%. Do you recall that?
I do, yes.
And again, this range is much closer to Mr. Bodino's recommendation of 9.10% than to your 10.75%. Isn't that true?
It is, and I know Mr. Baldino disagreed with this in his surrebuttal testimony, and I'm happy to talk about it more. But what this means is that if Mr. Baldino is going to directly compare accounting returns on equity to the cost of equity, then he's assuming largely that the only model that matters is the constant growth discounted cash flow model. They're not the same thing, the accounting return on equity and the cost of equity. The cost of equity is the return the next investor requires for the next dollar of capital they will invest. So they're different, and the only way they become the same is if you agree to all of the very strict assumptions underlying the constant growth discounted cash flow model.
But you included this information in your testimony, isn't that correct?
I did as a preface to looking at the pro forma scenarios. That's correct.
But you viewed it as information that the Commission should take into account.
In the context in which I provided it, yes.
Let's look at page 62 of your direct testimony. And that chart 8.
Yes, I'm there.
And it shows that the earned return for the proxy group on average common equity in 2017 was 9.17%. And this is very close to Mr. Bodino's recommended 9.10% return on equity, isn't it?
Right, and I won't go through it again, but they're not the same thing, and the only way they would be the same thing is if you used one model. But I agree with you, the numbers are close.
Going back to page 61, the prior page, you point out that the companies, in that same paragraph we had earlier been looking at,
Yes.
that the company's 2017 earned return on equity was 8.30%. So does not that support the reasonableness of Mr. Bodino's higher recommendation of 9.10%?
No.
And why is that?
They're two different things, and in fact, If you're going to say that the earned return on equity is 8.3% and it's going to fall even further than that, that dilution in earnings, that dilution in cash flow creates a risk for investors. As I said a minute ago, the cost of equity is the return the next investor requires to contribute the next dollar of equity. When they perceive that higher risk as a result of that lower earned return, that higher risk will cause them to require a higher return.
Well, let's remember that 8.30%, as we move now to the pro forma returns on equity part of your testimony.
Okay.
And in your direct testimony, you discussed the company's earned return on equity on a pro forma basis, looking at 4 different scenarios, including the merger customer benefit plan and a scenario where the experimental rate became permanent. Do you recall that?
I do, and these, of course, were data provided in Ms. Griffin's testimony.
So she prepared this information?
Yes.
Did you check her calculations and the data behind it?
When you say that the calculations, what I checked was the calculated return on equity number, but I did not go beyond that. I took them as given.
So do you recall what the pro forma earned return on equity was for the scenario of the experimental rates becoming permanent?
Is that the 6.67% number you're talking about?
That is correct. That's a positive number, isn't it?
It is it's more than 0, but I guess positive could be a term of art. But yes, it's greater than 0.
And doesn't that mean that the company on that basis would have provided a positive 6.67% return on equity after paying all interest costs on its debt?
It does. The question then becomes, is that level of return sufficient? Is the margin over the cost of debt sufficient? Does it give the company sufficient cash flow and liquidity? But yes, it's a positive number after paying interest expense.
In your rebuttal testimony on page 62, you said that Ms. Griffin has calculated the pro forma ROE associated with the ORS plan and has found the return to be, and I think this is where you corrected your numbers, to 7.66%.
You are right. That's where I corrected it.
After writing down approximately $2.5 billion in assets.
That's right.
This is also a positive return on equity, isn't it?
It's greater than 0, yes.
But it shows that on a pro forma basis, the company, this would be a return on equity after paying all interest costs on its debt.
Right. It does not assume that the impairment is restored. I think in my direct testimony, I noted that the 6.67% number that we talked about a minute ago, I believe Ms. Griffin found that it would be about 5.16%, giving effect to restoring the impairment. I don't know what that number would be here, but I do know that the pro forma number would be lower in this case if we were to give effect to restoring the impairment. We perhaps the same order of magnitude, I'm not sure, but it would be lower than 7.66%. It would likely be a positive number. Again, the question becomes how much higher than the cost of debt? How much will it provide cash flow and earnings and liquidity?
Ms. Griffin also determined a pro forma earned return on equity for the merger customer benefit plan. Isn't that correct?
I believe she did. Are you going back to my direct testimony?
Yes.
Okay.
Pages 64 and 66.
You'd be worried I'm starting to think like you.
You definitely should be worried.
Okay, I'm there.
And what was that pro forma earned return on equity in that scenario?
I'm sorry, which scenario?
It's the merger customer benefit plan.
Oh, the customer benefits plan was 8.83%.
And this 8.83% is way below your recommended return on equity of 10.75% and pretty close to Mr. Bodino's 9.10%, isn't it?
Yes, it's closer to Mr. Baldino's number. Again, I would say that we're talking about sort of different constructs in terms of the return on equity, but I agree with your math.
Let's step back a moment here and consider what the commission has to do in setting a return on equity. You note on pages 9 and 10 of your October 24 rebuttal testimony that the commission has said that, quote, the rate of return is not formula-based, but requires an informed expert judgment by the commission balancing the interests of the shareholders and customers. Is that correct?
That is correct.
And you say several times in your testimony that all analyses of these models require an element of judgment.
They do.
So looking at that Mr. Bodino's Sur rebuttal, table number 1, which we started with, which summarizes the mean and median results of your 9 analyses, your application of judgment ended up with a recommendation of a 10.75% return on equity, which is at the upper end of, but within the range laid out in table 1. Isn't that correct?
Well, remember, my recommendation is in the context of a range, but generally I would agree with that, yes.
And Mr. Bodino's 9.10% recommendation based on his judgment is also within the range of percentages laid out in this table 1. Isn't that correct?
Right, but it goes back to what we've talked about for a bit, which is the weight that ought to be given to, first off, focusing on a single method, and then secondly, the results of that method. But sure, his 9.1% falls right around the constant growth discounted cash flow numbers.
So if the commission in the exercise and application of its judgment decided to adopt Mr. Bodino's recommendation of a 9.10% return on equity, that outcome is in fact supported by the results of your analyses. Isn't that correct?
I want to be sure I understand your question. If your question is, does 9.1% fall within the range of results that I've produced? Yes, it is. If your question is 9.1% consistent with what I consider to be the important considerations in determining the cost of equity? No, it is not.
Here, what the commission is being asked to do is to set a rate of return, a return on equity for money already spent on a capital project that's been abandoned and will never be used to generate electricity. Now, the only reason to determine and provide a return on equity for sunken costs in this context is so the utility can attract equity capital in the future. Isn't that right? Isn't this what you call in your direct testimony the capital attraction principle?
Well, the capital attraction principle is one of the 3 Hope and Bluefield standards. But probably more importantly, I think you've hit, I think you're right. The question is, what return ought the commission set, knowing that that return would have implications for what I said a minute ago, the marginal cost of capital, the return the next investor will require to contribute the next dollar of equity.
And the NND capital costs that were incurred here were all pursuant to the Baseload Review Act. Is that not correct?
That's correct, yes.
And other than the VC Summer Plants Units 2 and 3, are you aware of any other capital project underway or contemplated in the state of South Carolina that's governed by the Baseload Review Act?
I am not, no.
And did you know that the Baseload Review Act has been repealed prospectively and for any other project?
I'm aware of that, yes.
So there's no possibility that any utility in South Carolina will be undertaking a future project under the Baseload Review Act, correct?
That would be my assumption, yes.
Therefore, the circumstance being dealt with in this proceeding is unique and will not happen again. Isn't that correct?
I've learned never to say never, but I would generally agree.
And what we have to worry about here, as we just talked about, is how this proceeding might affect the utility's ability to attract capital in the future. If the commission here expressly stated that the current circumstance is unique and the ROE it elects to use for the allowed NND capital costs here will not serve as a precedent, for any future determination of ROE for the utility, does that not simply resolve the issue?
I don't think it does. I think the question is going to be, what does that return do to the company's cash flow, and what does it signal to investors going forward? Does it resolve uncertainty? Yes. The resolution of uncertainty does not always mean that the cost of capital goes down, that the cost of equity goes down. It is a policy decision this commission has to make. I appreciate that. My testimony refers to the cost of equity. It refers to the return investors will require. And so if the commission were to say this is a one-time decision, I think the financial community would recognize that it's a one-time decision, but they would also look to the effect on the company's risk going forward as measured by the effect on cash flow, on the effect of its financial integrity.
Thank you. I don't have any more questions.
Thank you.
Thank you. Any other cross, especially for Ms. Lapson? You weren't getting up, were you, Mr. Elliott? Oh. That's a bad bluff. All right. Commissioners. Commissioner Elam.
Ms. Lapson, good afternoon.
Good afternoon, sir.
The credit agency reports attached to your rebuttal testimony state that SCANA and SE&G are currently in junk status and on negative watch, with the potential to be further downgraded if the experimental rate becomes permanent. Is that right?
I think different reports say different things, but I will accept your summarization
Of your
in
testimony?
a generic state.
Okay. The Baker Tilly and Bates White financial reports indicate that the company could take at most an 18% rate reduction and maintain mostly solid credit metrics. What causes the discrepancy in opinions between the credit agencies and the financial analysis reports?
Do you mean between the Baker Tilly reports and the credit rating agencies and my conclusions?
Right.
I reviewed the Baker Tilly results, and I don't believe that I found them to be well. I'm trying to be very polite here, but I don't think I found them to be very credible as being expert in credit ratings or financial solvency and solidity. My career has been based upon studying and analyzing on behalf of investors the credit metrics of companies, applying the credit rating agency's metrics. In some cases, earlier in my career, I developed some of those metrics that are currently used by Fitch Ratings. And I just, I wouldn't put a great deal of credence into their results in that particular very arcane art of credit advisory and ratings advisory.
Is it that difference that, well, I guess I get back to what's wrong with the way they perform their analysis?
I think they made a decision that was not based on using the metrics that the credit rating agencies use. And, I found their decision, their recommendation to be a little rosy, a little too optimistic. The science of credit analysis is not an optimistic view. It's a somewhat pessimistic view. They put a very rosy cast upon it, but I don't think that is the way those statistics would be interpreted by the credit rating agencies. And I would point out that in the federal case, I was challenged on my predictions of ratings downgrades by two agencies, and I was questioned and challenged on the fact that I predicted that those ratings changes would take place. And in that case, I was told that it was speculative on my part to assume that there would be any changes by credit rating agencies. That was the form of questioning that I received. And I would note that within days after the decision in that case, the ratings downgrades that I predicted took place exactly as I predicted. So it is my profession and the sum of my 49 years of experience in the financial community is to make these analyses, and on behalf of investors and on behalf of companies to advise them on what the credit rating impact and the access to the debt capital markets will be. And I think that's my field of specialization, and I am therefore that is the basis for the work that I've done in this case and in other cases.
Okay. I won't ever deny being dense sometimes. How was Baker Tilly too rosy in their assessment? I believe that's what you said.
I think they said if you take away 18% of the revenues, there won't be any effect. They'll still have viable and strong, and they'll be good. It's just the cash flow impact is pretty severe. We see that with a 14.8% reduction in revenues from the experimental rate, that the ratings, the credit rating agencies reduced the company's ratings. We see that the ratings right now are, by two agencies, are BBB- and Baa3, the very lowest ratings within the investment grade. That is the slippery slope. And BB+ by the third credit rating agency, Fitch. That's really the slippery slope. And so an 18% reduction. In hindsight, I'm validated by saying by the judgment that I made back then that the Baker Tilly results were not credible, because with a rate reduction that was less than the 18% that they said would be fine, there have been credit rating downgrades to an area that puts the company in a somewhat distressed situation. We have testimony from Ms. Griffin that says that the company is no longer able to issue commercial paper on a reliable daily basis to meet its needs, and instead can only borrow under its bank lines in those days when there are no commercial paper bids offered to them. So we know that that is a situation which is on the slippery slope of financial distress. They have reduced financing capability, and it's based upon a rate reduction that wasn't as great as the percentage that you say that Baker Tilly said would have no consequences. So I believe that validates my analysis.
Okay, thank you.
Commissioner Whitfield.
Thank you, Mr. Chairman. Good afternoon, Ms. Lapson. Good to have you with us.
Thank you, sir.
Two questions for you right quick. Number one, I noticed in your testimony, and of course here on your summary on the stand today, you of course have advocated against securitization, but let me just ask you one question. Yes, ma'am.
Well, before you go there, let me say I'm an agnostic about securitization. I am a neutral on that point.
Well, I think your testimony just said it has several potential negatives.
Right, and I was simply wanted to counter the view that it's a panacea, that everything about it certain, the ORS, Mr. Binns, and Mr. Can't think of the name of the other witness, but they all cited only positives. They provided only positives, and I wanted to balance that by stating that it is not a panacea. You should consider it carefully because it's a highly structured transaction is extremely inflexible, and once it's put into place, it would tie the hands of the commission in certain ways. So it does offer some benefits, but it also has some inflexibility and some things that should be considered on the contrary side when you are able to consider if that is becomes an option.
Well, I think you go on to point out those potential negatives that you mentioned, but I do want to ask you one question about securitization. You state that this debt would appear on the balance sheet of SCNG and remain in place many years. I believe it was the testimony of others that it would not appear on the balance sheet. Now, I really wanted to ask you about that.
I'm glad that you asked that. It does appear on the balance sheet of the companies that have issued those bonds in the past. If one of my fields of specialty is utility financial accounting, when I look at the financial reports of utilities that have issued those bonds do appear on the balance sheet of the utility. So there's a regulatory asset, and there's a regulatory asset that has been pledged, and there are bonds that have been issued, and under generally accepted accounting principles, the current requirement is that those would continue to appear on the financial statements of the utility.
Well, thank you for your answer. I guess we'll get a chance to ask these other witnesses about that. It was the way I kind of read it, once the legislation was enacted, that credit enhancements would be created and special purpose vehicles would be created, and that would not be on the balance sheet, but it's your testimony that it would remain on the balance sheet.
I can't make a determination about how this will be done in South Carolina, but I can say that I have been involved in securitization transactions as an analyst for Fitch Ratings, and before that as a commercial banker. And the results of that in all those cases that I was familiar with in the past, and that I continue to study the financial statements of the companies, those bonds are there. Now, some rating agencies, certain rating agencies, and certain bond investors and credit analysts make their own adjustment and remove those bonds when they do an analysis of the company, and others include them. But that's not to say, they're there on the financial statements, and when you look at the total debt of the company, that debt is there, the interest charges are there, it's all part of the consolidated view. This is why these are very complicated from an accounting standpoint, from a financial standpoint, and there's a lot of structure involved in these bonds. And I think that when the time comes, if you're able to study it, you will be learning a lot more detail about this very unusual form of financing. I have to disclose, I was involved in the very first transaction in the utility industry that created these bonds. For Puget Sound Power and Light. I was involved
at Washington State.
In the state of Washington. I testified in favor of the passage of a statute in Washington State to make that form of financing available, and that was the first transaction of this type in the United States. And so there was talk earlier today of solutions that are the least worst. And in some cases, securitization bonds are the very least worst. They're not necessarily a good solution, but they take something bad and make it least worst. And in order to, if the time comes that this becomes an option, you will understand, I think, that, for example, if there is destruction by storms, hurricanes, flooding, in many cases, the securitization transaction can provide a least worst solution. And so it's something to be considered. I certainly, it would be very difficult for me to say that I'm an enemy of these transactions, far from it.
Yes, ma'am. I believe I used that term, least worst, earlier today, and we certainly will get an opportunity to hear from those witnesses that have proposed that. One last question for you, Ms. Lapson. We heard witness Collins say that if the ORS optimal plan were adopted, that it would be near or almost 0% chance that SCE&G would be forced into bankruptcy. In your expert opinion, what percent chance would that be if the ORS optimal plan were adopted?
Commissioner Whitfield, I am so happy you asked me that question, because I heard Mr. Collin give that prediction, and I racked my brain to understand on what basis he could make that statement. And the only way that I can reconcile his statement with reality is that maybe he is, first of all, he claimed that he did not do a financial analysis of the whole company. He was only looking at the NND asset.
Right.
So I don't know how he could have made a prediction about the likelihood of bankruptcy without analyzing the whole company or considering the financial status of the whole company. So right off the bat, that seemed questionable to me. But secondly, I think maybe I could even make some sense out of it by saying, I can't say for sure that the result of the ORS, of putting in place the ORS proposal, would be an immediate and direct march from getting that order to the bankruptcy court to file in bankruptcy. That's not really what I have been saying was a likelihood. What I'm saying is that the likelihood of default, and I can only predict default, not predict bankruptcy, because default is a precursor to bankruptcy, and default is what happens when companies are in distress. Bankruptcy is an option and a right under the law, but default is what credit rating agencies and fixed income investors are concerned about, and creditors, suppliers, vendors, and so forth. And so the probability of default is not zero right now. The probability of default is, before anything occurs, is already a positive number, a non-zero number, and it becomes greater as the company's cash flows are eroded. As you erode the cash flows and write down the company's, the future stream of cash flow, the net present value of the future stream of cash flow, as that erodes, the company becomes on the slippery slope in which it can be weakened and perhaps not default immediately, but be in a period of financial distress. And that period of financial distress is a great concern. It's not just, bankruptcy isn't the only risk facing the customers and the public interest and the state of South Carolina. That period of financially distressed utility could go on for a period of several years of the company being in a struggle to balance its limited financial resources against the needs for investment, its costs, and the needs to maintain its system, to prepare itself for storms or for other adversities. And so bit by bit, the company can slide down that slippery slope from a double B plus or double B rating. It can slide down into the single B category. it can slide down into a period where its financial resources would be ever more distressed. So, for example, in the double B category, the meaning of a double B rating, the default probability associated with a double B rating, in 3 years after being rated double B, companies that have double B ratings have approximately a 5.7% probability of default. Within 5 years, they have a 10% probability of default. The financial community considers that a very meaningful risk, a significant risk. And as you get into of course, by that time, 3 or 4 years out, the company's credit rating may no longer be double B. It may be down to single B. And at that point, it would be very, very difficult for them to sustain their viability and to raise the kind of capital that is needed to keep their systems, their gas and their electric system operating.
So your answer for both the bankruptcy probability and the default, which the slippery slope period you refer to, neither one are close to zero.
Neither one of them is zero. I think that right now, a triple B minus rating denotes a probability of default in 3 years of about 2%, for example. It's not zero. And at a double B rating, about 5.7%.
Thank you, Ms. Lapson. Thank you, Chairman.
Thank you, Commissioner Whitfield. Commissioner Howard.
Thank you. Mr. Herbert, usually we come into a rate case or we're pretty well sure that the DCF is going to be the golden hair model we use. You virtually ignored it. You spent some pages explaining it, but all of the results come well below your range, recommended range. Can you discuss to me again why DCF wasn't used?
Well, first, I do consider all the results, the entire range of results, and I consider where my recommendation falls within that entire range. But as to my concerns with that model, there are several assumptions that it requires. It requires a constant price-to-earnings ratio. It requires a constant payout ratio. It assumes that the number that it produces today, the cost of equity today, will stay in place every day in perpetuity forever. My concern is that we know that financial market conditions are changing, if only because federal monetary policy is changing. We're getting out of the quantitative easing business. There was $4 trillion of assets on the Federal Reserve's balance sheet. It's starting to be unwound, and as it becomes unwound, interest rates go up. And when interest rates go up, the price-to-earnings ratio will change. Same thing when you think about utilities going through construction cycles and their payout ratios going up and then going down. So those assumptions will not remain constant. But to me, the principal issue is if we know interest rates are going up, we know the model produces a number of around 9%, we have to be comfortable that 9% will be the number every day from now on. And I just don't see that as reasonable at this point.
Well, thank you very much.
Commissioner Elam.
Ms. Lapson, you said you testified about Puget Sound.
Yes, I did.
Okay. Now, did the securitization there create problems that I believe you stated in your summary, an inflexible financial structure that could eliminate some future options? Were those problems present for Puget Sound?
It created an inflexible structure, but it was the least worst alternative. It was better than the what they were facing at the time. And so it was a very desirable thing to do.
Now, the inflexibility, isn't that part of the whole reason for doing securitization, that you know there's going to be the cash flow there for whoever is willing to buy into that?
In other words, to take what you're saying and to put it into different words, in order to make it possible to sell the bonds, there has to be a very, very strong commitment to make those revenues available and to provide a true-up mechanism so that the commission every 6 months or every year will recalculate the amount of charges to customers so as to create a stream of payments that is always exactly matching or very close to matching the requirements on the bonds for principal and interest.
Okay. And you talked about the possibility of eliminating some future options. Like what?
Well, I think it was Commissioner Whitfield. I'm not sure which one of you commissioners said it yesterday, but I heard some talk about things like distributed resources and other new types of demands for changes in the electric grid and the electric network. Well, at some time in the future, if people want to remove themselves from the grid, the form of issuance of the securitization bonds may require them to keep on making payments, grid payments, in order to support the bonds. Or if they're not required to do so, the commission would have to keep on reallocating the payment stream, the cash flow stream that is required, to an ever-shrinking number of customers, so that the last customer in would be paying a whopping bill, or the transaction would fall apart. So at some point in time, that's what I'm talking about the inflexibility and the fact that the commission might find themselves between a rock and a hard place, as some customers might seek to say, why am I forced to make these payments even though I'm no longer taking electricity? We've decentralized our source of power. Why do we have to make these payments? So commissioners might find this, especially with such a large transaction, I think it's $2.68 billion, if I remember correctly. And the proposed term of the ORS transaction is 20 years. That's a long, very long commitment. I don't know what the technology path will be, but I have a guess that there are a lot of things that could change in terms of technology that might make it difficult to commit now to have that very steady stream of revenues to service $2.68 billion of bonds.
Won't that be true, an issue about people leaving the system and continuing to pay base facilities charges or how much they should pay? We have that issue regardless of whether we do a securitization on this or not.
That's true. And I'm certainly, as I said before to Commissioner Whitfield, I'm not here saying that securitization bonds are a bad thing. I certainly would not. I am an agnostic about that. But I do think that there is a complexity to it that might not have been fully brought forth in considering this particular. Let me put it a different way. The proposal that was put forth by the ORS and by other intervener witnesses really does not discuss any of the potential inconveniences, inflexibilities of these bonds. And yes, the inflexibility of the securitization bonds is much greater than that which you encounter ordinarily as commissioners making decisions about the companies, the utilities that you regulate.
Thank you. Nothing further.
Thank you. Commissioners? Commissioner Irvin?
Thank you, Mr. Chairman. Ms. Lapson, we've heard testimony and seen evidence in this case that a former CEO retired, and I'm speaking of Mr. Timmerman, and then was paid $360,000 per year in a independent contractor agreement with no stated responsibilities, and turns out there's no documentation for any work that was ever performed. No reports were ever filed, and apparently no work was ever done. In your experience in public utility finance as an expert, what are your thoughts about that?
I'm sorry, I didn't hear that testimony, but I take it that it was presented. I find that to be rather shocking.
What should we do about that, in your expert opinion?
I'm sorry, but that's sort of outside of my range of knowledge.
Well, let me ask it another way. Have you ever seen that happen before in your years of experience in working with utilities in these type cases? Have you ever heard of such a thing?
I'm afraid I have heard of a lot of things.
I'm sure you have, but you've never heard of it. You've never heard of someone being paid that $360,000 a year and perform no work.
Well, if you and I could go out for a drink together after this, we could share some stories.
That's not allowed. Ex parte contact is not allowed. Thank you for the offer, but we're bound by the code of ethics.
I know some good stories.
Let me ask you another question, since you're, and this is my last one. Since you are a recognized expert in this area of utility finance, and we've also heard testimony that SC&G paid phantom invoices to Westinghouse as the project was winding down, just to kind of keep things going. What's your thought about that? Have you ever heard of a public utility paying phantom invoices?
Well, I also heard Mr. Addison's testimony today as I was sitting here in this room, and I heard him say that the word phantom wasn't really appropriate. So
that's the word that a prior company witness used. That's
I will
phrasing.
be very interested to read the transcript or to watch on TV the actual testimony that explains that. But I know I have a business, and I have in my business I have billed revenues and I have unbilled revenues, and I know utilities have both billed and unbilled revenues. And so, somebody could use the expression of phantom revenues to speak of my unbilled revenues, but eventually they all get documented.
But you would hope there'd be some accountability and checks and balances, and we're talking about millions of dollars that were paid out on these phantom invoices. So, how would you?
I'm not familiar with this topic, so
okay, all right.
I can't really
That's fair enough.
opine on it.
Fair enough. Thank you.
Thank you, Commissioner Urban. Anybody else? Well, we've heard a lot of new stuff today. Mr. Willoughby, any redirect? Thank you. Mr. Hebert, Ms. Lapson. And Ms. Lapson, I appreciated that, putting us in between a rock and a hard place. That's kind of where we live.
But, Commissioner Randall, sir, I would like to say that I have so enjoyed the comments from you that I'm going to ask for a summary of those parts of the transcript where you have delivered your stand-up chairman act.
I don't know if that's good or not, Miss Lambert,
I found it
But-
very,
but I'm going to smile about it. So, and I appreciate it. And you two folks are excused, and thank you for your testimony. Now, yes, sir.
Mr. Chairman, before we break, I did want to call to the Commission's attention that Mr. Kyle Young, who is on a panel that will be scheduled to appear at some point, or we had hoped to have already put up, but might come some point next week. Mr. Young's wife is going to have a child on Monday. She's being induced, so he is going to be unavailable next week. But we may do some rearranging of the panels, but I wanted the Commission to be aware.
I understand. Okay. And we've got a letter about that. Yes, sir, Mr. Elliott.
Mr. Chairman, before we break, in my cross-examination of Mr. Addison, I understood him to testify that on behalf of the company that he would be willing to submit evidence to this commission in the form of a late file exhibit with respect to the litigation costs and legal fees and so forth that the company was anticipating attempting to put in rates and make the ratepayers pay. And you correctly, after lunch, stated that I was in a zone, and I was in my cross-examination zone, and I don't know that we ever got that confirmed by a late file exhibit. I've stressed Ms. Wheat to the max, and she doesn't recall either.
Well, I know we were to talk to counsel about that, so.
Yes, I had hoped to confer with Mr. Addison about that over the break, but because he was still under cross-examination at that time, I was not able to. So if I could confer with Mr. Addison over the weekend, and we can report back to the Commission on Monday.
We'll make a note of that.
That's
Make
fine.
sure
I just
we
don't want it to
that.
get away from us.
Okay. Yes, sir, Mr. Richardson.
Not to prolong this, but we have some date certain witnesses for interveners who will be out of
Right.
order. I just want to make sure that we're going to start with them rather than with the next set of panels.
That's what we're going to do.
Thank
We're
you
going to
very
do
much.
that. We'll start with date certain folks. Okay. Anything else? Well, we kind of all need a nice weekend. I want to invite everybody this weekend to come to the Lawrence County Community Theater, where my 5-year-old grandson makes his stage debut as in the musical Winnie the Pooh as the tummy of Winnie the Pooh. And he won that part because he had the best burp. We're adjourned.